Hello everyone, hope you have an amazing day and welcome to my new blog. Today our topic is the Equal Remuneration Act 1976. Payment of remuneration at equal rates, men and women, workers and other matters. So a duty of employer to pay equal remuneration to men and women workers for same work or work of a similar nature. No employer shall pay to any worker employed by him in an establishment or employment remuneration, whether payable in cash or in kind, at rates less favorable than those at which remuneration is paid by him to the workers of the opposite sex in such establishment or employment for performing the same work or work of a similar nature in organization. No employer shall, for the purpose of complying with the provisions of subsection, reduce the rate of remuneration of any worker, where in a establishment or employment the rates of remuneration payable before the commencement of this act for men and women workers for the same work or work for the similar nature are different only on the ground of sex, then the higher in case where there are only two rates, or as the case may be, the highest in case where there are only two rates. Of such rates shall be the rate of which remuneration shall be payable on the form such commencement to such men and women workers, provided that nothing in this subsection shall be deemed to entitle a worker to the revisions of the rate of remuneration payable to him or her, with remuneration to the service rendered by him or her before the commencement of this act. No discriminations to be made while recruiting men and women workers. On the form of the commencement of this act, no employer shall, while making recruitment for the same work or work of a similar nature, or in any condition of service subsequent to recruitment, such as promotions, training, or transfer in organizations, make any discriminations against women except where the employment of women in such work is prohibited or restricted by or under any law for the time being in force, provided that the provisions of this section shall not affect any priority or reservations for the scheduled castes or scheduled tribes, ex-servicemen, retrenched employees of any other class or category of persons in the matter of recruitment to the post in any establishment or employment. Now, advisory committee, for the purpose of providing increasing employment opportunities for women, the appropriate government shall continue one or more advisory committee to advise it with regard to the extent to which women may be employed in such establishments or employment, as the central government may by notification specify in this behalf. Every advisory committee shall consist of not less than 10 persons to be nominated by the appropriate government, of which one half shall be women. In tendering its advice, the advisory or advisory committee shall have regard to the number of women employed in the concerned establishment or employment, the nature of work, hours of work, suitability of women for employment, as the case may be, the need for providing increasing employment opportunities for women, including part-time employment and such other relevant factors as the committee may think fit. The advisory committee shall regulate its own procedure. The appropriate government may, after considering the advice tendered to it by the advisory committee, and after giving to the person concerned in the establishment or employment an opportunity to make representation, issue such direction in respect of employment of women workers as the appropriate government may think fit. Now, the power of appropriate government to appoint authorities for hearing and deciding claims and complaints. The appropriate government may by notification appoint such officers not below the rank of a labor officer as it thinks fit to be the authorities for the purpose of hearing and deciding complaints with regard to the contraventions of any provision of this Act. Claims arising out of non-payment of wages at equal rates to men and women workers for the same work or work of a similar nature, and may by the name, same or subsequent notification define the local limits within which each such authority shall exercise its jurisdiction. Every complaints or claims referred to in subsection 1 shall be made in such manner as may be prescribed. If any question arises as to whether two or more workers or works are of the same nature or of a similar nature, it shall be decided by the authority appointed under subsection 1. Now, where a complaint or claim is made to the authority appointed under subsection 1, it may, after giving the applicant and the employer an opportunity of being heard, and after such inquiry as it may consider necessary, direct. In the case of a claim arising out of a non-payment of wages at equal rates to men and women workers for the same work or work of a similar nature, that payment be made to the worker of a amount by which the wages payable to him exceed the amount actually paid. In the case of complaint, that adequate steps be taken by the employer so as to ensure that there is no contravention of any provision of this Act. Every authority appointed under subsection 1 shall all the power of civil court under the Code of Civil Procedure 1908, 5 of 1908, for the purpose of taking evidence and of the enforcing the attendance of witnesses and compelling the procedure or production of documents, and every such authority shall be deemed to be a civil court for all the purposes of section 195 and chapter of the Code of Criminal Procedure 1973, 2 of 1974. Any employer or workers aggrieved by any order made by any authority appointed under subsection 1 on a complaint or claim may, within 30 days from the date of the order, prefer an appeal to such authority as the appropriate government may by notifications specify in this behalf, and that authority may, after hearing the appeal, confirm, modify or reverse the order appealed against, and no further appeal shall be against the order made by such authority. The authority referred to in subsection 6 may, if it is satisfied that the appellant was prevented by sufficient cause from preferring the appeal within the period specified in subsection 6, allow the appeal to be preferred within a further period of the 30 days but not thereafter. The provisions of subsection 1 of section 33C of the Industrial Disputes Act 1947, 14 of 1947 shall apply for the recovery of monies due to from an employer arising out of the decision of an authority appointed under this section. Now, miscellaneous duty of an employer to maintain registers. So, on and from the commencement of this act, every employer shall maintain such registers and other documents in relation to the workers employed by him as may be prescribed. Inspector. The appropriate government may, by notification, appoint such persons as it think fit to the inspector for the purpose of making an investigation as to whether the provisions of this act or the rules made thereunder are being compiled with by the employers, and may define the local limits within which an inspector may make such investigation. Every inspector shall be deemed to be a public servant within the meaning of section 21 of the Indian Penal Code 45 of 1860. An inspector may, at any place within the local limits of his jurisdiction, enter at any reasonable time with such assistance as he thinks fit any building, factory, premises or vessel, requires any employer to produce any register, muster roll or other documents relating to the employment of workers, and examine such documents also, take on the spot or otherwise the evidence of any person for the purpose of ascertaining whether the provisions of this act are being or have been compiled with, examine the employer, his agent or servant or any other person found in charge of the establishment or any premises conducted therewith, or any person whom the inspector has reasonable cause to believe to be or to have been a worker in the establishment. Make copies or take extracts from any register or other document maintained in relations to the establishment under this act. Any person required by any inspector to produce any register or other document or to give any information shall comply with such requisitions also. Now, penalties. If after the commencement of this act, any employer being required by or under this act so to do omits or fails to maintain any register or other document in relation to workers employed by him, or omits or fail to produce any register, muster roll or other documents relating to the employment of workers, omits or refuses to give any evidence or prevents his agent, servant or any other person in charge by the establishment or any other worker from giving evidence or omits or refuse to give any information. He shall be punishable with the simple imprisonment for a term which may extend to 1 month, or with fine which may extend to 10,000 rupees, or with both. If after the commencement of this act any employer makes any recruitment in contravention of the provisions of this act, or makes any payment or remuneration at unequal rates to men's and women's workers for the same work or the work of the similar nature, or makes any discriminations between men and women workers in contraventions of the provisions of this act, or omits or fail to carry out any directions made by the appropriate government under subsection 5 or section 6, he shall be punishable with fine which shall not be less than 10,000 rupees, but which may extend to 20,000 rupees, or with imprisonment for a term which shall be not less than 3 months, but which may extend to 1 year, or with both for the first offense, and with imprisonment which may extend to 2 years for the second and subsequent offenses. So that's for the end of the video, my friends. If you like my video, please subscribe my channel. Thanks a lot for watching.